Success for your business depends largely on your ability to distinguish your company's products and services from those of others in the marketplace. Developing a strong brand image that stands out from your competitors is one way to achieve that goal. However, it takes a substantial investment of time, money, and care in order to cultivate a strong brand image. So, it is very much something worth protecting. One way to achieve that goal is to register the trademarks that your company uses or intends to use in order to support its branding and reputation. My name is Tanner Ukazalian and I'm a Canadian trademark agent at Craig Wilson & Company. Today I look forward to discussing with you the process for acquiring trademark protection in Canada. Let's get started. Selecting a trademark can be a challenge unto itself. There are some things to think about when it comes to choosing a strong trademark, which I will cover in another video. For the sake of our discussion today about the trademark process in Canada, I'll assume you have a trademark that you may already be using or have one in mind that you intend to use. Once you've identified a trademark you intend to register, you should consider having a search made. This is part of the process that people are sometimes tempted to skip, but in most cases it's hands down the most important part of the trademark process. Even if you've done some searching on your own, I strongly recommend you have a thorough search made, possibly with the assistance of a registered Canadian trademark agent. The purpose of the search is to identify trademarks which are the same as or are confusingly similar to your own, which might be owned or used by others in the marketplace in similar areas of business or commerce. The search helps you to be aware of the potential risks associated with using your trademark and helps you decide if you should continue with the trademark you're currently looking at or to discard it in favor of a new one instead. It may sound counterintuitive, but the search finding a trademark which is identical or confusingly similar with your own is not necessarily a bad outcome. You can file a trademark application without a search, but then you run the risk of accidentally using someone else's trademark, or a trademark which is confusingly similar with one that they own. This could result in that other party taking steps to apply their trademark rights against you. Not a great way to start your trademark journey. I recommend you reach out to a trademark agent, such as myself, to assist you with the search. A trademark agent will be in the best position to assist you with identifying the scope of the search, interpreting the results, and providing you with an opinion as to any potential risks associated with using your trademark. Try not to be frustrated with the search results if they aren't favorable at first, especially if you're searching a trademark which you have not yet put into use. Once you've searched your trademark and are comfortable with the results, it's time to prepare and file your Canadian trademark application. The most common type of trademark application is for a standard wordmark or a logo, otherwise known as a design. There are other more specialized types of trademark application which can be made, such as for sounds, scents, holograms, or 3D shapes. However, if you are interested in one of these more specialized types of trademark application, I strongly recommend you reach out to a trademark agent since their filing requirements are more complicated. Once your trademark application has been filed, it will soon after that become visible on the Canadian Intellectual Property Office's online trademarks database so that you and other people can see it and review the details of the application. After a period of time, an examiner at the Canadian Intellectual Property Office will review your application. The time frame within which an examiner has that first look varies depending on the workload faced by the office. Sometimes that can be high, and so it may take several months, in some cases more than a year, for the examiner to have that first look. So don't be surprised if you don't hear anything about your application immediately after it's filed. If you're curious about the status of your application, you can check the online database, you can reach out to your trademark agent, or if you filed the application yourself, you can contact the office directly with your questions. During examination, the examiner will review your trademark application for compliance with the Canadian Trademark Act and the Canadian Trademark Regulations. If the examiner believes for any reason that your application is not in compliance with the Act or the regulations, then the examiner will issue a letter known as an examiner's report. The examiner's report outlines any issues the examiner may have with your application and requests correction, clarification, or your comments in response. Try not to be too surprised if you receive an examiner's report on your application. The examiner can raise many different objections based on many different regulations and stipulations in the Act, and even with the assistance of a trademark agent, it's very difficult to anticipate what exactly the examiner will see when they review your application. Also, it is possible that the examiner may issue more than one examiner's report during the course of the prosecution of your application. Once the examiner believes that your trademark application is in compliance with the Canadian Trademarks Act and the Canadian Trademarks Regulations, notice will be sent indicating that your trademark application will be advertised in the Trademarks Journal. The Trademarks Journal is a publication which allows third parties to review trademarks which are intended for registration. Your trademark application will be advertised for a period of 2 months. Within that 2-month time frame, third parties will have the opportunity to review your trademark application and will also have the opportunity to oppose your trademark application. Opposition is essentially a mechanism which allows third parties to challenge the registration of a trademark application which the office finds to be allowable. If your trademark application is opposed, I strongly recommend you reach out to a trademark agent for assistance. Opposition proceedings are administrative proceedings before the Canadian Trademarks Office and have a large number of procedural rules and practices associated with them. Failure to respect proper practices can jeopardize your trademark application, so the support of a trademark agent is recommended. Opposition in Canada proceeds in stages. The initial stages of opposition are not very expensive. However, the later stages can become quite expensive. If you're looking to control costs, opposition proceedings can be terminated at any time by either party. However, understand that if the opposition proceeding is not resolved in your favor, then you'll lose the rights to your trademark application. If no opposition is raised or if all opposition matters are settled, then your trademark application will proceed to allowance and registration, and the office will send a certificate of registration. Once your trademark is registered, it will appear as a registered trademark on the Canadian Intellectual Property Office's online trademarks database. The registration will be visible to yourself as well as to anyone else searching the database. The rights to a registered trademark are applicable throughout Canada for a period of 10 years and provide you with an assortment of benefits, including an enhanced means of enforcing your trademark rights against others who might be infringing your trademark. This 10-year period is renewable in 10-year increments with payment of a renewal fee. As of the recording of this video in June 2021, you should expect the process from the filing of your trademark application through to registration to take at least 2 years in Canada. This is in part due to a change in law which came into effect in June 2019, and also in part due to disruptions caused by the COVID-19 pandemic. A more realistic time frame in view of these circumstances is 3 to 4 years for your trademark to go from filing through to registration. However, you do not have to wait for a trademark registration in order to begin using your trademark. You should have a good awareness of the risks associated with using your trademark once the search has been made and the results have been reviewed. I hope that the information presented in this video has been helpful to you. I encourage you to partner with a trademark agent to help you navigate through the Canadian trademark application process and to ensure that your application is aligned with your business goals. My name is Tanner Hukazeli and I'm a registered Canadian trademark agent at Craig Wilson & Company. It's been my great pleasure speaking with you today about the process for acquiring trademark protection in Canada. I look forward to seeing you next time. Thank you.